Hello, everyone. Thank you for joining us today. I'm Lauren Remus. On behalf of America's Job Exchange, thanks for getting with us today and for joining us for Compensation After EEO-1, Component 2, What's Next? Before we get started, I have just a couple of quick items to share. Questions on today's topic will be answered at the end of the presentation, but you can feel free to submit your questions at any time. Please use the chat function in order to do so, and we will get to your questions, as many as we can at the end. Anything we aren't able to answer today, you'll get a response from us via email in the next few days. Also, since we do get this question a lot, we will be sending a copy of the presentation and a link to the recording to you after the broadcast. Please allow 1 day for delivery of that email. Thank you. And finally, after this event, a link to a short survey will pop up. If you'd like to help us out, we would love for you to click on that link and answer a few short questions. Tell us what you thought of today's presentation. Your input definitely helps us shape our programming, so please let us know. Thank you. And now let's move on to what we all came here for, today's presentation. I'm pleased to introduce Dr. Thomas Carnahan, Principal Organizational Psychologist and Statistician at Outsolve. With his mix of statistical and human resources skills, Thomas helps Outsolve customers understand the value of equal pay for equal work, regardless of a person's identification with any federal, state, or local law, guideline, or ordinance. Thomas, thanks for being with us. I'll hand it over to you.
My pleasure. Thank you, and thank you for welcoming me in all of your offices and conference rooms. And if you're driving, please pay attention to the road. Good afternoon to everybody who is, I guess, Mountain Time Zone and over. Good morning to everybody west of there. Today, we're going to be talking about what do we do now. The EEO Component 2 was not necessarily a shock, but it was definitely something that was compressed timeline-wise, because I think we were all moving forward as if it was not going to happen, and then all of a sudden it did. So, there's going to be some conjecture here. There's going to be some guessing. There's definitely more options as to what can be done with Component 2 than what's going to be presented here. And then also how that might interact with other future laws that are coming. But first, let me take a little bit of time to just introduce where I work. So Outsolve has been in business now for 21 years. We just celebrated our 21st anniversary. And primarily, we are an affirmative action company, so producing plans, filing vets, EEO-1s, Component 2, all of that kind of stuff is what we do for all of our customers. But recently, of course, we've been moving aggressively into HR analytics, HR consulting, and doing things for our customers on the 4 bullet points that you see here on litigation support, audits, HR programs and policies, and then, of course, proactive pay equity, which is a different beast than doing something for litigation. We are headquartered just outside of New Orleans in Metairie, Louisiana, and we have offices all over the country, with a most recent one that we have in Maryland in the D.C. area. So again, I'm excited that everybody chose to be here with us on this beautiful rainy afternoon in New Orleans. And today I'm just going to kind of talk about, again, what is the future of compensation-related topics as we move on past this first collection of EEO-1 Component 2? I'm going to give a couple possible changes that might be coming in the coming years to Component 2 and how the federal agencies collect compensation data and what that all means. We'll take a little bit of time to talk about other things that might be coming vis-a-vis the Paycheck Fairness Act, which has passed the House of Representatives but is not going to pass under this administration, but who knows what could happen in the future. We'll also talk about how there's a lot of states that have come in to try to fix what we know, the federal government thinks is wrong with current federal pay equity laws. And so there's a lot of states that are trying to enact their own legislation, and how that can definitely change how you look at compensation federally versus what do you need to do inside the state. For example, Massachusetts, which has a very interesting state pay equity law. Then I'll just go through some basic recommendations to all businesses that you should start thinking about and looking into. And like Laura said, we'll have plenty of time at the end, I hope, to answer as many questions as we can, but she'll forward the rest of those questions on to me and my team. We'll answer them, and we'll be able to send out a group email to everybody to make sure that everybody gets those questions answered. So let's go ahead and get started. The future of EEO-1 Component 2. So what we know now is that everything is ruled by OMB control numbers, and whether or not the control number is alive and valid versus whether or not it's not going to be renewed is not under debate. The EEOC has two control numbers for active EEO-1 Component 1 and Component 2 form numbers. They have renewed the EEO-1 Component 1, and that renewal did not include anything about compensation. So what we thought when they first did this back in 2016, that they were going to combine these forms together to limit the amount of paper, the Paper Reduction Act. That didn't happen. So Component 2 is kind of still wavering out in the air because they've announced that it's not going to be renewed beyond the date that they agreed to keep it open as part of the federal ruling, the circuit court ruling against them, stating that they needed to collect the 2017 and 2018 data that we all just got done doing by September 30th. That stays open until April 2021. That form is active and an OMB active form number. So this is what we know that has been said, and these are from Janet Dillon and Vicki Lipnick, both at conferences, and Janet Dillon being called to testify in front of House committees. So this is what we know that they have said, that they are going to continue to collect Component 2 as long as the court order is in effect. That could come in a multitude of different ways. They could keep the September 30th date and therefore, in effect, really only have to do this one more time. So do it in 2020 to collect for 2019. But since there would be no active form in September of 2021, then they would not need to collect data in 2021 for 2020 because the form would no longer be active as of April 2021. The other thing that they could do is go back to the date that it was supposed to be done, collect it at the same time as EEO-1 Component 1, and then they would need to do two more collections. They would collect 2019 in March of 2020, and then collect 2020 in March of 2021. But we do know that they said that they are going to follow the law, they are going to follow the ruling of the judge, and collect Component 2 data as long as the court order is in effect, and we know the court order is in effect until April 2021. They're also going to use Title VII and the Paperwork Reduction Act to try to lift the burden. They know, especially with the hours worked, that this was a cluster. This was a problem for organizations and businesses, and we all spent a lot of time and a lot of money and a lot of resources to try to collect this data. And there's still just a ton of questions out there on how to handle certain data. I know we've been, looking at all this data and figuring out ways that we can pilot and research our customers that filed their Component 2 with us. There's just a lot of things we don't know. For example, the entire transportation industry, individuals who are truck drivers, we don't measure their production and how we pay them by hours worked. It's done by miles or some combination of miles and other activities, and it's ruled by the federal, NTSB and different things. And so, companies were struggling to figure out what do we put in hours worked for more than just truck drivers, but that's a great example. So there's a lot of questions that we need answered, and it's a lot of work, and the EEOC recognizes that. And in that, they kind of want to go towards something that maybe can get them closer to pay disparity instead of wage gap. Because what they got this year, how they collected data on 2017 and 2018, and what this form is going to collect until April 2021 has nothing to do with a company's pay disparity. And pay disparity is if there are differences when you hold everything else equal, time in company, time in job, education, all of these things that we know should be determinants as to why people get paid different money, and you create those pay analysis groups in order to lump people together. You have pay disparity if after controlling for all of that, there are still differences between males and females. That's not what wage gap is. This is what wage gap is. And across an entire company, department, division, wage gap exists when there are more, let's say, males at the higher end. So just looking at this chart, imagine that pay band 7 pays more than pay band 1. You'll notice that there's a relationship here. There's a change of ratio. From pay bands 1 through 4, there's more females than males. And then as we move on to the higher paid pay bands, the ratio changes to more males than females. This is, of course, a made up but perfect determinant of an example of what wage gap is. That, in the HR department, there are more males at higher pay grades than females. And we know that this exists in our society, and it exists for a multitude of reasons that have nothing to do with organizations, have nothing to do with companies. Right? It has a lot more to do with expectations when parents are raising their children. Do they have equal expectations of their male children than their female children? And parents today treat that differently than parents in the 40s and 50s and 60s. Opportunity for equal education. Parents or even schools pushing young girls into doing careers that are suited for a woman, things like that. And we know that attitudes around these kinds of things are changing, right? And so wage gap does exist, but it's not illegal. It's just something that we all need to recognize, we all need to understand, and it's something that's going to be interesting for the EEOC to report on because we have very good estimates based upon census data, but this is going to be some really interesting, good data because it's, based upon what's written down here. One of their big limitations at the EEOC is that they got that W-2 box 1, which I understand why they wanted to go for that because that's the, kind of the best estimate maybe for total compensation at a company. It's not a great one by any means, but it's the best one that they could get their hands on easily. And so, they're going to be able to provide not only, hey, census data is self-reported. Most likely, most people are only self-reporting their base pay, their annualized base pay. So now we have this stuff on total compensation. Is there a huge difference? And so do we have to start thinking about pay equity and other things when it comes to variable pay and benefits and things like that. So there's going to be some fruitful information come out of it, but not anything that companies should really be, overly worried about, other than the fact that you just spent a ton of time getting this information together. Pay disparity, though, is different. It has nothing to do, in a sense, with society as a whole, but it still doesn't mean that it's the company's fault that you have pay disparity. Most pay disparity exists because a company has extremely well-intentioned policies and procedures that still turn out to provide some kind of adverse impact against a protected group for something that was definitely not intended to happen. The policy was created, it was intended to keep everybody equal, it's just not working how it was intended to be. But that doesn't, that's good. That's better than willful discrimination, but it's still adverse impact, and it's still something that we need to deal with. And this is just an example of what, a basic analysis using multiple linear regression would look like. So in this case, the variables, the things that we're controlling for when we look at the differences in gender, for this company's data is time in company, which we see is very significant, so that's great. That means that the more time that somebody is spending at the company, then the more they are making. Wonderful. Time in job, again, significant because of that asterisk. Wonderful. The more time somebody spends in their job, the more they're moving up their quartile ranges and their pay grade, they're making more money. Wonderful. External experience, we kind of like to see this one close to zero. We don't want to see this one be highly positive in a way, because that means that the company's rewarding people that bounce around from job to job, from company to company in a way. Education is positively related to getting paid more. Certifications are positively related to getting paid more. And one that my customers are always surprised about is that trainings, special trainings, and how many trainings you've done in a year is usually negatively related to pay. And what I always remind them of is, yes, you do have your go-getters. You do have your top performers that want more training and get more training, but what percentage of people really are doing it because they are already a top performer versus how many people are getting assigned training because they have some kind of deficiency? So training might be negatively related to pay because a lot of people are doing trainings because it's on their individual development plan. So a lot of times we see training be negatively related to pay. Finally, you can see the gender there. Gender is significant, meaning that there are differences between males and females, and that the practical value difference is, on average, females are making $2,142.17 less than a male who has equal time with company, time in job, external experience, etc. So that's the difference between the two. Wage gap is more of a thing like, hey, we just need to all take a step back and make sure that we are giving equal opportunity to people. Pay disparity is, hey, we need to take a step back and think about the policies and procedures at your company. We're not accepting blame. We're not saying that we're biased. We're not saying that we're bigots. What we're saying is we need to take a step back, review these things that have the best of intentions, because I'm sure they do, but see if that even with the best of intentions, something has creeped in that we need to handle and address. All right, let's move on to, what are some implications of the potential changes? So I'm going to present to you two potential component 2 changes moving forward and what those implications might be to you guys as employers. Option 1, kill it. Don't collect component 2 again. We still think that they're going to have to do it at least for 2019 if they keep it in September, but at a maximum 2019 and 2020 under this current form. And if they change it back to March. If they kill it, though, what does this mean? Well, many organizations are going to have spent hundreds of thousands, if not millions of dollars to try to update HRIS, payroll, other systems to try to accommodate getting this data quickly and easily, not just a one-time thing for 2017 and 18. We talked to a lot of our customers, and we know that they're saying, we don't want this to be the problem that it was this time. We don't want to spend weeks trying to get data for a report to the federal government. So we're asking a whole bunch of people to build things so that we can get this faster. Well, if you build all of that and then they kill it, well, what a waste of time and money. Even though they might kill it, let's not forget that the data is still usable and searchable for the EEOC and OFCCP, for those of you who are federal contractors, for up to 3 years. For those of you who are only under the EEOC, some of the speculation out there is that this information, should they receive a complaint about potential discrimination in pay or in compensation, they may take into account your amount of wage gap to help them certify a class in a class action lawsuit. There's a lot of ways that this data could be, misused. The OFCCP, for those of you who are federal contractors, they also get this. And if your name comes up for an audit and they pull your EEO-1 Component 1 and Component 2 results, they may choose to do a check on the location that they think might have the most pay disparity by looking at wage gap at that location. So this data is still relevant for at least 3 years or so, even if they don't collect it anymore after it is killed in April 2021. And then, once again, we have the potential of an entire federal program getting ramped up. And I'm going to give the EEOC the same credit as I would any company. I don't think they had any ill intentions. I think they're just trying to enforce the law. But this program is going to be viewed as a burden if it's just killed. It's going to really have no major fruit that any of us are going to be able to do anything with. And it's going to widen the gap, widen the barriers between the EEOC and companies working together to enforce and follow the law. And I think that's just, it's something that I hope the EEOC takes into account if they decide to just kill it, that it's really going to hurt their organization instead of help, all of us just kind of like move on and understand that compensation is here to stay. The other option that the EEOC could take is doing something a little bit more related to pay disparity. Collecting data that's not as hard, not as difficult for companies to collect. Like, when did you hire them? That's in your system already. When did they enter their current job? What's their birth date? And all that kind of, be able to collect this level of data so that they could run basically a risk analysis for pay disparity for each company. Now that's definitely scarier on the what could they find front, but maybe easier on the can we get this information to the EEOC faster and without having to spend weeks programming things and pulling data and trying to figure out what to do with it. This is, I guess, a second possibility. There's probably, 50 more. But these are the two, ends of the spectrum that we wanted to present. So they could either kill it, and that's just not great for anyone because we've all spent a lot of time and money in gearing up and figuring out how to do this and do it very quickly. Or they could choose to make it more about pay disparity instead of pay equity, instead of wage gap, and utilize things like annualized base pay and other things. Now, in and of itself, if they just did this, it's scary, but it's not super scary because the EEOC is still a federal agency that cannot bring a lawsuit against a company without a plaintiff, without a complaint. They're not a proactive, they're a reactive federal agency. So I always compare them to the USDA. The USDA does not need to wait for a company or people to get sick in order to go inspect a farm. They have the understanding of a federal agency and the legitimate power of an agency to go inspect at any time to make sure that farms and other people that make food, et cetera, are following established guidelines because it's all about safety. It's all about making sure that the law is being followed. The EEOC can't act that way. They have to wait for a credible plaintiff to come forward with some really good proof, not just I believe I am, because the burden of proof currently is on the EEOC, is on the plaintiff to prove that the company does have disparity, not the other way around. So even though this is scary that the federal government getting this information is not great by itself, it doesn't lend to the EEOC firing off a whole bunch of lawsuits. However, in connection with something else that might pass, the Paycheck Fairness Act, then we kind of have a perfect storm for the EEOC. The Paycheck Fairness Act basically is going to do 6 things. And again, it did pass the House. It is being held. It is not being presented in front of the Senate for a vote. I think, of course, that the party that passed this is hoping that there is a change next year in administration and also potentially in the Senate. So the earliest this could be signed into law would be 2021, so we do have time to think about this and prepare. So I'm going to go through the 6 major things that the Paycheck Fairness Act is going to do. First of all, it's going to update the definition of a work establishment. So for OFCCP purposes, they won't be confined to a physical address. They can branch out and look at substantially equal jobs or pay analysis groups at employers' places of businesses in any kind of political subdivision that makes sense. So by county, by state, etc. So they're not going to be limited to physical location when it comes to analysis of compensation. The EEOC as well. You know, sometimes when they go in and look, they look at it as just this location. They have to fight hard and find, you know, more pervasive disparity to expand that. Well, it won't be so hard for them to expand the area in which they want data to analyze. It helps clarify what the current Equal Pay Act says as factor other than sex defense. So right now it can be anything. You could come up with whether or not they choose orange envelopes or manila envelopes to store things, and if that helps explain the differences in your pay and you know makes gender go from being significant to non-significant, then great. Color of manila envelope is a valid use in the regression equation to explain pay. So it's going to clarify that to say that the factor that you bring in to the regression equation must be bona fide and job related, not just anything else. So so what they're encouraging you to do, just like the OFCCP, if anybody's read 2018-05, their new directive on compensation, what the federal government as a whole and state pay equity laws as a whole are trying to do is really encourage companies to have a written down practice, a compensation philosophy, something that you follow and can be explained to employees, to lawyers, to judges, and it makes sense. So that's what they're asking for. The third thing that the Paycheck Fairness Act is going to do is it's going to strengthen remedies for violations, and it's going to bring it more in line with the Civil Rights Amendment. Right now, what you can do for remedies for gender-based discrimination is different than for racial-based discrimination, because one is EPA, the other one is the Civil Rights Amendment. And especially if it's been proven that's intentional discrimination, and there's 2 kind of like definitions of that, and I'm not a lawyer, so I'm not saying they're legal definitions, but they're definitions for those of us in the pay equity realm. Intentional discrimination is kind of defined by 2 things. One, you're intentionally discriminating. You have some kind of smoking gun email from the CEO that's sent out to recruiters saying don't pay women as much. That doesn't happen. So the other intentional discrimination is if you do a proactive pay equity, you lift the hood on it, right? Somebody tells you you've got some risk, there's a problem that we need to talk about and investigate more and look towards fixing this, and then you choose to do nothing about it. So it's a willful ignorance kind of a thing. So they're going to work harder towards getting this information, trying to break privilege in a way so that they can get access to compensation studies and things like that, and increase those punitive damages. Next, 4 through 6. Number 4 is going to update class action provisions. Right now, again, in the same one as 3, there's a difference in how to be able to form classes between if it was a racial case versus a gender case. So the Paycheck Fairness Act brings those into being equal. It brings gender up to the standard of race. So all members will be treated as part of the class unless they specifically say, I'm not. The fifth is it's going to strengthen the oversight of the Department of Labor and the EEOC. So they're going to be directed to continue to collect data of compensation and employment-related data to help both of them, the DOL, which is mostly the OFCCP, and the EEOC, detect violations and improve enforcement. And what that really does, like there's wording in there that what it does is it's going to shift the burden of proof. Instead of the burden of proof being on the plaintiff, being on the EEOC, or being on the OFCCP to prove that the company does have practices that create pay disparity, it's going to be the company having the burden of proof and having to prove that they do not currently have any pay disparity. And in a way, what that does is it shifts the mandate of the EEOC. Like the OFCCP can proactively audit. So it's not going to change their mandate a whole lot, but it's really going to change the EEOC into being more like the USDA, where they don't need an active plaintiff anymore. They can request data, go through data, and identify practices that they want to meet with you and talk about, and sue on behalf of the workers to get back pay and increases that the statistics, the multiple linear regression, and other things show that they deserve. So this is where it gets dangerous. And that right there, combined with a component 2 that becomes more about pay disparity, gives them a lot of information on the front end, the ability to analyze that information, and then file a lawsuit or request more information without a plaintiff. This is where it gets, really concerning, okay? The sixth thing that it does is it prohibits retaliation for any disclosure of salary. So seeking redress, inquiring about wage practices, running out into the hallway and screaming to people, I've been here for 5 years and I make $50,000 a year, is going to be protected. The Paycheck Fairness Act, as well as I think it's 8 or 9 state laws, want to protect people because one of the best ways that they see is a grassroots campaign. By employees feeling more comfortable about talking with pay with each other may bring pressure on more companies to do a proactive evaluation of their data and fix any concerns that are found by that proactive look. So this is kind of the grassroots bullet point here. So if you can't retaliate, then you can't do it. Now, one of the things that they've said, in talking about the Paycheck Fairness Act, as well as other state laws, is that you can limit when and where, when it's practical for people to be able to do this on your breaks, on your lunch, do it in your office, but please don't interrupt other people doing what I just said was an example of going out into the hallway and screaming what you make. Still be a professional about it. So there are limits that employers can put on it, but they cannot retaliate against somebody who follows those limits. So again, what does all of this mean? Well, it means that if the Paycheck Fairness Act passes and gets signed into law, the EEOC is not going to need a plaintiff anymore. Now, are they going to continue to accept complaints? Of course, because there's things the Paycheck Fairness Act doesn't cover. And they're not going to get to every business right away as well. So they're still going to accept complaints. And they may be getting a whole lot of data to help them make these judgments with component 2. So, in a way, our recommendation is there's 3 things that you need to really be able to feel comfortable sleeping at night. 1, a written down compensation philosophy. That is policy, it's written down and accepted. You need to do what's known as a comparable worth study. We highly recommend that you do a market analysis that isn't strictly just based on the market. And then a proactive pay equity is just essential. Knowing where you stand, knowing where your risks are, and discussing with a professional what you can do about it is just is just essential. Especially in this day and age. You know, there's been other movements in the past, and they've kind of gone away after 6 months or a year. But this movement that started in 2015, you know, #MeToo, Time's Up, it's not going away. The calls for equal pay, the calls for more companies to take this seriously, the calls for laws to be strengthened, the pressure on elected and unelected officials to make this happen hasn't waned at all in almost 4 years. But, you know, again, if there's two things that you walk away from this interaction with me, is number one, by no means is anybody blaming companies for pay disparity. I guarantee every one of you have well-intentioned policies and procedures. The second one is the sky is not falling. You know, there is some conjecture here, but what we do know is that the window might be closing on being able to start and end a process of pay equity before these things pass and get enacted. And the reason I say that is because if you do a pay equity and the consultant, whoever it is, the expert, finds some things that you need to address, you probably want to take a little bit of time to do so under attorney-client privilege. If they find that on average women are making $2,500 less than men in the HR department, you don't want to give people that much money in one paycheck. That could signal that some people need to start suing for back pay. So to do this well and to protect the company from more risk, if risk is identified, you want to be able to take some time, 3, 4, 5 years, to spread out some of these changes that need to bring people into line. All right, let's talk a little bit about state pay equity laws because they continue to expand as well. The federal government is kind of struggling to enforce the laws they have. The EEO-1 keeps getting their budget reduced. The OFCCP keeps getting their budget reduced. So they're trying to learn how to do more with less. They're also, you know, on the legislative branches, trying to pass new laws and to strengthen them, but it's a lot harder for the federal government than it is for state and local governments to pass their own laws. With Alabama being the most recent state to pass a pay equity law within their borders, 49 states now have their own pay equity legislation, with most of them being more powerful than the federal government's regulations. Namely, the states at the bottom are even, you know, are more along the lines of what we would expect to see in Europe or Canada. They offer these states, New Jersey, New York, Massachusetts, Colorado, especially the Colorado law that's going to go into effect in January 2021, Illinois, California, Oregon, Washington, and Alaska, have provisions in them that make them very unique. And some of these include criminal action. For example, in New Jersey, for every paycheck that goes out, that the company knows that these paychecks are have disparity, the CEO of the company can receive a misdemeanor under state law for each paycheck. So if you're paying 500 women less than they should be getting paid, then that could be 500 misdemeanors per paycheck. So over a year, that's really going to add up. Massachusetts, that I mentioned earlier, and Colorado is going to have a very similar law to Massachusetts starting in 2021, are very complex and difficult to deal with because they only allow you to use specific variables. Every other law, the federal laws and the other 47 state laws that exist, all put in a provision that you can use other job-related variables. They say the ones that you should use, time in job, time in company, education. They say the ones that you should use, But then they say, but we're willing to listen to and accept any other job-related variable that you think is important to your company, leaving that window open for your company to be unique. Well, not in Massachusetts or Colorado. They tell you exactly what variables you can use, and you cannot use anything else. So those are really difficult, especially if you have decided to do a nationwide proactive pay equity. You not only have to make sure that you're doing your analyses on the basis of federal law, then you have to take a step back and go into each one of these states that have their own unique laws and make sure you're safe there too. It's a very time-consuming and difficult process, which is why we always recommend that you hire an expert to do that for you and then lock that down under attorney-client privilege with preferably an external attorney and not an internal attorney. State pay equity complicates things. Beyond what I just covered about being safe federally, but then you do a Massachusetts study and you find out you're no longer safe in Massachusetts, there's other things that you need to take into account. New Jersey, for example, that's not up here on this slide, they don't just protect race and gender, they do every federal or state protected class. So transgendered versus non-transgendered, homosexual versus non-homosexual, HIV positive versus non-HIV positive. So it's like 19 different categories. And that gets really, really, really complicated because the question is I think all of us understand how difficult it is to just ask the basic questions of, do you have a disability or not? Are you a veteran or not? Imagine having to send out an employee questionnaire saying, hey, let us know if you have HIV or not, but don't worry, we're not going to use this for anything. I mean, no one's going to say yes. I mean, so there's a lot of things to these laws that are difficult to comply because that information needs to be voluntary. And so there's just a lot of weird things, and state pay equity can really complicate things, which is why I say always have an expert by your side. So what are the overall recommendations that we would make? First of all, evaluate your compensation philosophy. Number one, is it written down? If an OFCCP compliance officer or an EEO-1 litigator came into your director of compensation's office and said, show me the policies that dictate how people get paid at your organization, can you do that? Is it followed objectively? And that's always a tough one because there's always exceptions to every rule. But once you make an exception, that becomes policy because you need to make that exception every time going forward. How simple is your compensation philosophy versus how extremely complex is it? A lot of the state laws are going to the idea that if two people came into your office and said, we both went to Harvard, we both have 10 years of experience, we both have the same certifications, I make $10,000 less than he does, why? You need to be able to explain that. And if you can't, then, that's, again, where we're talking about subjectivity comes into play. So you need to evaluate your philosophy around compensation. You need to evaluate all of your policies and procedures that touch pay to make sure that they're, one, valid, that they are acting in the way that you intended them to act, and that they are objective. Subjectivity, from what I see from doing proactive pay equity and litigation support here at Outsolve, comes from basically two different places. One, starting pay, and the other one, performance management systems. All right, starting pay typically comes from you have a very, very, very well-intentioned policy of that you do a 10% increase based upon what somebody was making at their last job. Now, you're following the state laws. You're no longer asking people in places like California, what did you make at your last job? But you might be using the workaround, what would you like to make here? Which is basically just the same thing. And when you ask them, let's say you have two candidates, Bill and Mary, they're both engineers. They both went to the School of Mines, which is a very good engineering school, I've been told. They both have 5 years of experience. They both have extensive certifications in mechanical engineering. When you say, what would you like to make here? He says, I'd like to make $100,000 a year. So you add your 10% because he's within range of your budget, and you make him an offer of $110,000. Based upon what she was paid before, she says, I'd like to make $80,000. And you say, great, we're going to get a wonderful candidate with an amazing education, and we're going to save money. So we're definitely going to hire her too. She's a great candidate. We're going to add our 10%, and she's going to be making $88,000 a year. So what was a $20,000 difference between these two prospective employees is now a $22,000 difference, and they are your employees. They are now your responsibility when it comes to pay disparity. So that's kind of, even though that is an objective policy, it creates some subjective problems moving down the line. And then you throw in performance management, and it just keeps getting bigger and bigger. That $22,000 difference between the two employees, if they both receive a 5% raise because they're both shooting stars in performance management, they're going to get even further apart. And performance management systems tend to be more subjective than they need to be. And so you know, having some expert advice or relooking at your performance management system to close as many gaps as you can around subjectivity is highly recommended as well. The next thing you might want to ask yourself is, when is the last time we did a market analysis, and are we using pay grades? Because pay grades are a pretty good way to establish a pay analysis group. Even though these people may work in different departments, the pay grade analysis indicates that they have the same minimum, midpoint, and maximum when it comes to their compensation. So that's a good place to start if you want to create pay analysis groups. A valid market analysis is great, but we're starting to see some weird things. So we at OutSolve, we do market analyses as well, and we're starting to see some weird things creep into market analysis data. Most of it has to do with baby boomers retiring in certain fields. So certain fields that are dominated in a sense by older workers, and so they're commanding a large salary. As more and more and more of them retire, we're seeing the midpoints, the mins and maxes, actually shrink. So even though inflation is going up, GDP is going up, the economy is strong and good, there are a multitude of positions out there in which market analysis is indicating you should be paying your employees less. That has less to do with the market, in a sense, but more to do with generation gaps and the fact that we have a ton of older workers who are retiring. So we need to take that into account. And then there's this whole idea of comparable worth. There's a lot of theory and some proof that there are differences in pay for occupations that have traditionally been controlled by males versus occupations that have been traditionally controlled by females, in that those traditionally female roles are paid less. I'll give one example that helps start this debate from our neighbors to the north in Canada. There was a big study done in the healthcare industry in Canada concerning orderlies versus people who are cleaners in the healthcare industry. Orderlies definitely do have some cleaning as a part of their role, but they're not doing the big cleaning. They're not doing the ORs and things like that. The things that you have to clean or things go really wrong, right? Orderlies, for a large part, are doing things like moving patients around, making sure they get to radiology, wheeling the patient out when they get discharged, et cetera, et cetera, et cetera. When they started to study those jobs, they used criteria to determine what's the responsibility of these jobs, what skill level is needed to do this job, and what's the accountability. What would happen if something goes wrong? And what they found as a part of that study is that cleaners are actually more difficult. Being a cleaner takes more skill and is a more difficult job, and it has more risk associated with it. If you clean that OR wrong, a patient gets a staph infection, they die, the hospital's liable because the employee had malpractice, right? They did something wrong. Orderlies had less of that. There is definitely still some risk, of course, to doing their job wrong, but there's less of it. But then when they looked at the pay, the cleaners made less than the orderlies. And the only thing that they could associate that to, after looking at a multitude of different ways to try to figure out why cleaners make less than orderlies, is that because it is a female role. And they were getting paid less because it's traditionally female. So a comparable worth study looks for things like that. Where are there potentially places where the job does not have the societal or typical worth that it should have because it is a predominantly, historically female role? And then the last recommendation I would have is, please start discussions at your company to get a proactive pay equity study. You definitely want to protect this. So whatever you think you need to put into the budget for the proactive pay equity, you also want to budget for an attorney. Because you want that attorney to retain the expert and to keep all of those results and things protected and outside of your company. So the overall last recommendation I have is, and I don't mean to say this because I know our competitors sell these, and this is not has anything to do with any of them because I love healthy competition. But do not trust off-the-shelf software solutions for pay equity. They cannot keep up to date with law changes. They by themselves are not an expert. The thing about software, the thing about statistical software, is it's going to give you an answer. It's going to find a way to spit out a result, and you're going to just, hey, we bought this. We're paying for it. And we definitely, trust that this is giving us the right answer. And then you go out and you make a whole lot of changes to your compensation, and you could potentially be making things worse. The use of multiple linear regression is very iterative. The multiple linear regression equation that I would use in the HR department is different from the accounting department. It's going to be different in your finance department. It's going to be different in your engineering department. It's going to be different for your entry-level hourly employees. It's a very iterative process, but it's hard to do that if you're not building an appropriate equation, if you're just using a software and you don't have that expert guidance. And then the big reason why I would strongly suggest you consider not doing that or abandoning that practice if you already do is it's going to be hard for that software to know the nuanced differences between federal and state pay equity. And so where you've done and spent all this money to make changes based upon the R-square and information from the multiple regression that was given to you by this software for federal pay equity, maybe now California and Massachusetts, which tend to be the most litigious states, are now completely out of whack. All right, so now I'm going to open the floor for questions, and while those are being compiled and stuff, just remind, we do have a blog where we release information about compensation information as it happens. We're on LinkedIn and also Twitter.
Fantastic, thank you. We did have one question just related to what you were just discussing. Could you give a quick definition of what you mean by off-the-shelf pay software?
I mean, there's people who have these branded softwares that they say that you can purchase a licensing fee, we'll load it up, and then it'll constantly give you advice about your pay equity. You know, I don't want to say the names of any of these companies that have this because, again, I don't think any of these companies are bad. I would just strongly recommend that if you're working with a company and they say, hey, you know, we can sell you this product that will do pay equity for you, really, you know, take a good hard look at whether or not you want to do that, because it's going to give you, you know, in a sense, a false sense of security. But they are for sale. There's probably 10 different types that are for sale. You know, just be careful because my job here is I don't care if you use me or not. I just want you to be safe.
Fair enough. We also had a question that came in a little earlier, going back to the Paycheck Fairness Act, but I think you kind of circled back on this. You had mentioned perform a market analysis that's not just based on market info. Where else should folks be looking?
Well, what I would suggest is hire somebody that's going to take it a step further and not just look at this year, but look at trends over time and alert you to, hey, this one's not acting in accordance to inflation. This one's starting to go down. We might have an area here where this is due to people retiring. The other thing I would say is look at comparable worth. Just because market analysis says this is what a cleaner makes, that may not be what a cleaner deserves. So those are the two big things that I would take into account in which you use this external market data, but also understand the internal climate at your company.
Okay, well, that brings us to the end of our session. We have no more questions. So thank you, Thomas, so much for a great presentation today. This is great information. Thomas's information is there if you'd like to reach out to him. You can always reach out to us at America's Job Exchange should you have any questions or follow-up comments. Thanks to everyone for joining us. This concludes our presentation. We hope to host you again in the future. Have a great rest of your day.